Well, specifically with regard to patent protection, if you've developed a new technology or you think you've come up with a new idea, I think the most important piece of advice I could give anyone is not to disclose it to the public before you filed a patent application. It seems like one of the few bits of information which everyone doesn't know, which is as soon as your device or method or new invention as a whole is public in any way, you can no longer file a patent application or it can be invalidated at a later point. Well, with regard to inventions or whatever you've come up with, it's about what sort of protection is suitable for you. In intellectual property, there are 4 main categories of protection involving copyright, trademark, design and patent protection. And each of them covers a different element with regards to what can be protected. Inventions, and especially technological inventions, tend to be protectable by patents, which can protect a system or a method of doing something. And with regard to seeking protection, you need to think about what exactly it is which makes your invention both new and inventive over what's already been disclosed to the public. Obviously, the best situation is if you can afford to pay to cover all of the inventions you have. However, there are ways of delaying payment for certain things. Also, a single application can be used to file for a number of inventions and file separately divisionals later on. However, going back to my previous point, as soon as an invention is made public and disclosed, then you can no longer file patent protection for it. Therefore, the best advice is to try and protect as much as you can before you make your invention public. Well, a lot of our work is done on the clock, as many legal professionals do, and the time it takes to draft and file your application will very much depend on the type of subject matter that's involved. If it's a very simple device involving 2 bits of wood, then perhaps it'll be a lot cheaper than it will be to draft a patent application relating to a new form of semiconductor technology. Overall, you can expect to spend upwards of £6,000 to have your patent drafted and filed, and that cost can go up depending on how complex your device is, up to about, I would suspect, £12,000. The UK Patent and Trademark Office do allow individual inventors to file their own applications, and there's no reason for you necessarily to contract a patent attorney to draft and file your application for you. However, without sounding selfish, it's incredibly well advised to speak to a legal professional to assist at some point. It's like going to court. You don't have to have your own lawyer, and you can represent yourself if you want to, but you're far more likely to trip up at some point and get something wrong. It's the same with drafting patents. You're paying for our professional advice, and a patent that you draft and file yourself may not be very useful in the end, or probably has a much lower chance of getting granted in the first place. No one is obliged to tell you if they're infringing your patent. Unfortunately, it's not a case where the patent office will get in touch with you if they find any technology. However, if you become aware that someone's infringing your patent, again, I recommend getting in touch with a legal representative in order to discuss the scope of your granted protection. On the flip side, the entire patent registry is public and it can be searched through company name or subject matter sector, and it's possible for the individual inventor or small firms to search the patent databases and get a better idea of what other technology is protected by other parties and whether they might be infringing other people's patents as well. Upon becoming aware that your patent has potentially been infringed, the first thing to do would be to contact a legal professional, because we can help in determining whether actually there is a case to take things forwards or whether you've misinterpreted how much your patent actually grants you protection. An important thing to remember is having a patent application is not the same thing as having a granted patent, and you can only enforce your patent once it's actually granted. Therefore, it's important not to make any threatening communications to potentially infringing party, as these can result in fines against you. So first of all, ensure that your patent is granted, and then speak to a legal representative who can help you assess exactly the scope of your granted patent and what your options are afterwards.